Hello, everyone, and welcome to Uncivil Law. For today's case, we have a situation wondering what the scope of a Terry stop is. So police don't have cause to arrest you. They want to conduct a brief investigation. How brief is that investigation is the question. That brings us to the case of John Hall versus City of Chicago. In this case, panhandlers were violating various ordinances. The police investigated. As part of it, they ran a name check to see if this person had any warrants. These checks sometimes would last 5 minutes, sometimes 10, and at least occasionally, apparently a little bit more, up to 15 minutes. The question is that valid under the Terry stop regime for a brief investigatory stop? Let's get started with this. The plaintiffs in this case ask us to address the proper scope of the Terry stop. Police officers stopped plaintiffs numerous times for violating an ordinance while they were panhandling on the streets of Chicago. During the course of these stops, the officers typically asked the plaintiffs to produce an identification. The officers then proceed to use the cards to search out for any investigative warrants or other alerts. The plaintiffs brought out an action under 42 U.S.C. 1983 against the City of Chicago, claiming that these name check procedures unnecessarily and unconstitutionally prolong the street stops and the delays constitute an unreasonable detention in violation of the Fourth Amendment. They assert the city maintained an unconstitutional policy or practice of performing these name checks. So, the brief stop as part of violating an ordinance relating to panhandling, that's okay. But checking the names requires more time. So perhaps that's an unconstitutional extension of the purpose of Terry. For many years, the police department used contact cards to document the Terry stops between police and citizens. Each card contained information about the individual, including address, social security number, driver's license number, and employer information. Between January of 2010 and January of 2016, the police department documented 3.3 million street encounters with citizens using these cards and the successor form, the investigative stop reports. In 2/3 of these cases, but they include a notation on the card, something like name check clear or NCC or NC clear, indicating that officers completed a name check. So of these police officers during a 6-year period are doing 3.3 million of these interactions. That's a lot of interactions. And in roughly 2/3 of the ones, there's a document that says, or documentation that says they conducted a name search. So at least 2/3 of the time, when they're stopping these people for whatever, they're also checking to see if that name flags for any warrants or other police investigative reasons. So this is a fairly common practice by the Chicago police, or at least it was at the time. In the deposition testimony, several officers testified that they generally would conduct these name checks during an investigative stop, and it was up to their discretion whether or not to do so. They testified that typically they asked citizens for cards during the street encounters, and people usually waited for the officers to return their cards before they would leave. They also attested that preventing the subject of stop from running away motivated the practice of holding on to the ID. So once they ask for ID, they're not going to give it back until they're done with the process. Until November of 2018, Chicago had an aggressive panhandling ordinance, which prohibited certain behaviors while panhandling. It's a little unclear what happened after November 18. Did the ordinance go away? Was it modified? I don't know. But at least until November 18, 2018, they had an ordinance. So that ordinance made it unlawful for a panhandler to solicit a person at specified locations, such as within 10 feet of a bus stop or public bus, in a restaurant, in a gas station, or within 10 feet of an ATM. The ordinance also prohibited touching a solicited person without consent, blocking the path of a person entering a building or vehicle, following a solicited person, or panhandling in a group of 2 or more persons. So there's a whole bunch of regulations which apparently are, to some degree, no longer on the books. The plaintiffs in question are residents of the City of Chicago who have panhandled in the city. The police officers stopped plaintiffs numerous times and documented those stops with contact cards. From 2005 to 2015, Chicago police records show 65 contact cards for Garner, 7 for Franks, 36 for Pindack, 33 for Dennis, 54 for Hubbard, and 53 for Hall. So these are the specific named plaintiffs. So we're saying how many contacts are at least documented. Because there might be ones that are not documented, but how many were documented. So in a 10-year period, we have these number of documentations. So we're at a height of looks like about 6.5 per year for Gardner, and to lesser degrees other people, but it is a fairly routine occurrence, I guess, in the grand scheme of that. So there's lots of these interactions. As to how long these interactions took, Dennis testified that a call to the dispatcher for a name check took maybe 2 to 3 minutes and maybe a minute or two of delay. Several of the other plaintiffs testified the warrant checks or these name checks took anywhere from 4 to 7 minutes, about the same time frame. Franks on the high end testified that on one occasion, he estimated 11 to 15 minutes between the officer asking for ID and returning ID. So in terms of how long these detentions are, we have a range of testimony that is roughly in conformity. So somewhere between 2 and 8 minutes, something along those frames. So it's a bit of a delay, but is it an unconstitutional delay is the critical question. Let's press on. The plaintiffs filed suit under 42 U.S.C. 1983 against the city of Chicago and the individual officers, alleging that the unnecessary delays that result from blanket warrant checks unrelated to the reason justifying the stop constitutes an unreasonable seizure under the Fourth Amendment. The plaintiffs do not challenge the use of the contact card, so they challenge the detention, not the documentation. Okay, fair enough. The district court denied the motion and granted the city's motion. In doing so, the district court held that if the officers had a reasonable suspicion of an ordinance violation, they may permissibly detain an individual to investigate the violation. Therefore, there was no underlying constitutional violation to succeed on the Monell theory of liability. So the district court said that this is not a problem because they had suspicion to investigate the panhandling ordinance, and they can investigate according to that ordinance, so no problem according to the district court. Let's read on. The Supreme Court held in Monell that plaintiffs may sue municipalities when their actions violate the Constitution. In order to succeed on a Monell claim, a plaintiff must prove 3 elements: that there was action pursuant to policy, that there was culpability, meaning policymakers were deliberately indifferent to known risks the policy would lead to violations, and causation, meaning that municipal actions were the moving force behind the injury. As a threshold matter, the plaintiffs must demonstrate the policy at issue violates their constitutional rights. Okay, so now we have to figure out what are the constitutional rights at question. We have a detention pursuant to a Terry stop, but we have some investigation perhaps beyond the bounds of the reason of the stop. We stopped them because they were panhandling illegally, but now we're running checks beyond that. So what are the standards that apply to a stop, and when does a stop imply the Fourth Amendment protection? Let's read on. Whenever a police officer accosts an individual and restrains his freedom to walk away, the police officer seizes the person. The test for whether a seizure has occurred is objective. We ask, consider the totality of the circumstances, whether a reasonable person would feel free to terminate the encounter. Circumstances that might indicate a seizure include threatening presence of several officers, displaying the weapon, physical touching of a private citizen, use of forceful language or tone of voice, indicating compliance that is compelled, and the location which the encounter takes place. So we have various things that help us determine whether or not there has been a seizure within the meaning of the Fourth Amendment. Of consequence, merely asking for identification does not amount to a seizure under the Fourth Amendment. The Supreme Court has provided, in the ordinary course, a police officer is free to ask a person for identification without implicating the Fourth Amendment. Interrogation relating to one's identity or request for identification by the police does not, in and of itself, constitute a seizure. Questions concerning a suspect's identity are routine and accepted as part of a Terry stop. Knowledge of the identity may inform an officer that the suspect is warranted for other offenses. So the police can ask for lots of things. Whether or not you have to give it to them is a whole nother problem. But merely asking is not a violation. Indeed, even where officers have no basis for suspecting a person and have no reason to stop on its own, they may generally ask questions and examine the individual identification, so long as the police do not convey a message that compliance is required. So even if police don't have a reason, they can ask anything because anyone can ask anything. So as long as the police aren't saying that you have to comply, if they're merely saying, do you have any ID? Can I see some ID? I mean, anyone can ask that. So you have a right to say no, unless they're ordering you. So, you can always say, no, I don't want to present it. And if they order you to, well, then you're in a different world, aren't you? We conclude that officers' initial requests do not constitute a seizure. We therefore turn our analysis at the heart of the claim, whether the time factor in the handling of the ID and the returning it is a seizure. So the initial inquiry is not a violation because anyone can ask anything. And an officer can ask anything. Says, can I see some ID? And you say, sure. You're complying with their request, which anyone can ask. So the question is not the initial request, but maybe the amount of time that is involved becomes the violation. All right, let's try that. Pindak testified when he asked for the officers to return his ID, the officers told them they could not leave until they were finished running a check. So that might be a seizure, right? Garner similarly testified the officers told him that they'd let him go if the name check was clear. Consistent with Pendek and Garner's testimony, the officer asserted that she instructs individuals on whom she performs name checks. They're free to go if their name is cleared. Considering these explicit instructions in the light most favorable to the plaintiffs, they've raised an issue as to fact as to whether or not a person would feel free to leave. They've therefore demonstrated an issue of fact exists as to the seizure. So there's at least some testimony from some of these people saying, I wanted my ID back and they wouldn't give it to me. And some of them saying, oh, well, they said I couldn't leave until the name check cleared. So that now is at least a seizure. So now we've accomplished a seizure for at least some of the facts. So there could be a reasonable fact finder could find this was a seizure. But of course, not all seizures are prohibited. So now we have to go to the next part of analysis, whether this was a reasonable seizure or not. So even if it was a seizure, which maybe it is it a reasonable seizure? All right, let's discuss. We therefore proceed as to the question of whether these potential seizures were reasonable under the Fourth Amendment. Because it's uncontested that the officers observed the plaintiff violating the aggressive panhandling ordinance, they have reason to suspect the Terry stops of these individuals. It is nevertheless clear a seizure that is lawful at its inception can violate the Fourth Amendment if the manner of execution unreasonably infringes the interests protected by the Constitution. Okay, so I just would like to take a brief note here, although it's a bit of an aside, that this is also relevant to the ongoing George Floyd case and the ongoing liability of Derek Chauvin. Now, obviously, we're in a slightly different context, so, take it with a grain of salt. But the Supreme Court is pointing out here that something that is lawful when it starts doesn't necessarily continue to be lawful indefinitely. So merely concluding, for example, that Derek Chauvin was legally within his rights at the start of the interaction with Floyd isn't necessarily dispositive that it was lawful at the end, because, again, comparing and contrasting to the Fourth Amendment analysis, just because it's lawful at one point doesn't necessarily mean it's continuing to be lawful, particularly if the manner in which it's executed unreasonably infringes the interests that are protected. So much like that situation, this situation true. Just because it was lawful at the start doesn't mean it's perpetually lawful. And so we have to analyze the lawfulness on an ongoing basis. So the panhandling people might have a claim, and Derek Chauvin also might have some liability for comparably similar reasons. In the traffic context, the Supreme Court has said that beyond determining whether to issue a traffic ticket, an officer's mission includes ordinary inquiries that are relevant to the traffic stop. These inquiries usually involve determining whether there are any outstanding warrants. These checks, the court writes, serves the same objective enforcement as the traffic code, ensuring the vehicles on the road are operated safely and responsibly. So the Supreme Court said these brief checks are fine, at least in the motor vehicle context. Several of our sister circuits have expressly held that officers do not exceed the permissible scope of Terry by running a warrant check, even where the warrant check is unrelated to the underlying crime. And also we now agree. The plaintiffs note that the above cases all are different in at least one respect. They involve traffic stops rather than street stops. Fair point. They argue the concerns about driving safety the court mentioned in Rodriguez do not play here in the street stops, different concerns. And thus these warrant checks are not incidental to street stops like they are with the traffic stops. We're persuaded, though, by the 10th Circuit views of this issue, which disagrees. We therefore hold an officer's completion of a warrant check during a street stop where the officer has reasonable suspicion of criminal activity is not per se unreasonable under the Fourth Amendment. That is not to say, however, the completion of a warrant check that extends the duration of a street stop is always reasonable. Indeed, the length of delay impacts the reasonability analysis. Thus, while a warrant check might require some delay, the delay may not be unduly prolonged. Here, most plaintiffs testify that they estimated the warrant checks typically delayed stops anywhere from 4 to 7 minutes. No reasonable jury could find this length of delay is unreasonable in the length of these circumstances, particularly where the plaintiffs were unable to recall any of the specificities of their alleged encounters. Even when reviewing the evidence in the light most favorable to the plaintiff, the longest delay of 11 to 15 minutes, as Frank claimed, appears to be an outlier. But in any event, this extended time frame is within the bounds of what this court and our sister circuits have determined to be reasonable when officers have reasonable suspicion for the underlying original stop. Therefore, because the name checks of reasonable duration performed when officers have reasonable suspicion of ongoing activity do not violate the Fourth Amendment, the plaintiffs have failed to raise an issue of fact they've suffered an underlying constitutional violation. The city thus cannot be held liable under Monell. Thus, that brings us to the end of our discussion of John Hall versus City of Chicago. In this case, the City of Chicago was stopping people who were illegally panhandling and asking them for ID. And as part of that was checking their name to see whether they had any warrants. These interactions typically took about 5 minutes, although there may be a little bit more, a little bit less typically. And so the court says, well, you had initial grounds to stop. You can conduct this as part of an ongoing investigation as long as it's not unreasonably delayed. And these kinds of delays are not unreasonable. So without more, this is not a violation of your rights. And so you can't hold the city responsible for the policy here. And so that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.